Today we will talk about child pornography, specifically the offense of possession of child pornography and the offense of distribution of child pornography. As horrific as the issue is, it becomes more complicated when one looks at the particular levels of the sentencing guidelines. We will discuss those levels of the sentencing guidelines, which obviously take place only if a person is convicted of either or both of these offenses. This presentation will not talk about production, that is, when you entice a child or get a child involved for the purposes of filming or taking a picture of a child in a sexual act with an adult. This will simply be a discussion of downloading from a website into a shared file, and then there will be a disclaimer on the website, if you so choose to download from that website, that unless you agree that the images that you download, to include videos, are in a shared file and can be used by others, you must agree to that in order to be permitted to enter into the website. The simple agreement means that the image goes into a shared file. That constitutes distribution. It doesn't matter if no one decides to pick up the image out of the shared file. It doesn't matter if you do not trade actively images with other individuals that might be engaged in child pornography. The mere filing or the mere downloading of an image into a shared file is sufficient to constitute distribution. The statute prohibiting distribution of child pornography carries with it a mandatory minimum statutory penalty of 5 years. There is no mandatory minimum for the offense of possession of child pornography. Let's talk a little bit about enhancements. The enhancements in the Federal Sentencing Guidelines 2G2.2 include, for instance, the number of images that an individual has. If an individual maintains a level of 600 or above, that increases by level 5 from a level 22, and then you're at a 27. If the guidelines, for instance, holds or includes if the child is prepubescent, that is an additional level 4 increase. If in fact you have, from a practical standpoint, only, for instance, 400 images, which count for 1 point toward the 600, that keeps you down. However, if you in fact have videos, the videos count for each video, regardless of the length of the video, 75 points. So if an individual has 25 videos, obviously that kicks him well above the 600 level. Back in December of 2012, the Federal Sentencing Commission authored a 200-page report to Congress. And in that report, the Commission was highly critical of the guidelines as it applied to possession and distribution of child pornography. Some of the criticisms include the fact that the guidelines initially started when, in 2004, the PROTECT Act permitted the various enhancements to be included into the sentencing of individuals charged with possession and or distribution of child pornography. The problem is that the current level of the application of the federal sentencing guidelines fails to differentiate between the culpability of one defendant versus another defendant. Back in the early 2000s, the computer age was just starting to come of age, and if an individual engaged in child pornography, it would normally be by mail. Obviously, 600 images shared by mail is a significant number. With the use of the computer, which increases your levels by 2, with the use of a computer, and everybody uses a computer to some degree, you can literally download thousands of images, and will not have the time for an ordinary normal person to view each image that is downloaded. Many images I have found that are downloaded are never viewed by the defendant, simply because there isn't an interest, bestiality, violent acts against children appearing in the video may not appeal to the child pornographer. So the guidelines were criticized by the commission that formulated the guidelines because it did not give the senator an opportunity to differentiate between the person that is being sentenced by that particular court. In any event, I think it's wise for the defense lawyer to become familiar with this report. There's an executive summary, and to include in that report, or to include in any type of objection that might be filed or request for downward departure, items out of the report that reflect upon the attitude of the commission at this moment in time toward Congress to, in effect, reinvent the guidelines and bring them up to date so that individuals can be properly adjudicated and properly sentenced according to the level of their involvement.